the hotel in the trial court showed a video to the jury as a demonstrative aid, which is an inappropriate recreation of the hotel's version of events. And this presentation was reversible error. What we'd like to do is we request through this appeal to remand the trial court for a new trial based on this error. The video was a demonstrative presentation that showed...
Can I ask you a question
Yes,
that wasn't
Your Honor.
clear to me from the record we got? Was there an objection to the stuntman, I'm going to call him, to the stuntman's testimony at all?
Your Honor, there was not. There was an objection to the video presentation.
Okay, well, my question then, follow-up is, seems to me, and I've watched the video, that the video is nothing more than shows what his testimony reflected. So didn't you waive the entry of the video by not objecting to the testimony?
Your Honor, we believe that Florida law does not require that by failing to object to something that everything arising afterwards necessarily would be admissible at that circumstance.
No, clearly you could say, the video is more prejudicial than his testimony, arguably, and I understand that.
Yes, Your Honor, because the
But
question...
it seemed to me in this case, though, that all the video did was reflect what he testified to. It wasn't spectacular, per se. You understand what my question is?
I think I do, Your Honor, and if I may clarify. The case law that we've shown in our briefs, in fact, my opposing side has also shown in the brief that the videos independently have to be substantially similar to the underlying facts of the case. And this is, independent of testimony. This is a matter of evidence law in terms of what should be shown. And the reason why that the video is different than the testimony itself is the video shows something that's purporting to be what the assailant did at the time period, and that in and of itself and must have a foundation, and the foundation of it is a substantial similarity to the underlying circumstances.
But why is his testimony even relevant then? That's kind of my thing. If it has to be substantially similar, why is his testimony even relevant if he's not an expert witness?
Right, that's absolutely correct. It wasn't very relevant.
I just understand that argument,
Right.
but there was no objection to his testimony.
That's correct, Your Honor, but we're not objecting to his, the appeal today is not about his testimony. The appeal is just about the video that was being shown.
Okay, I understand your answer. Go ahead with your
Thank you so much, Your Honor. To elaborate, the trial court erred because it applied the wrong legal standard. It came to the opposite conclusion that it should have, given its findings that it made. Particularly, the basic rule for the presentation of any demonstrative video is that the proponent of such a demonstrative video must lay a particular foundation for that video, and that foundation must show the substantial similarity of the underlying circumstances and the evidence to show the substantial similarity. The only exception to that kind of video is an abstract scientific experiment video provided by an expert. This principle of law, that there must be a substantial similarity, is absolutely universal. It's in every case involving videos that we have put in my initial brief as well as the answer brief. And it cannot be reasonably stated that this is not the standard by which it should be applied. The fact of the matter is that this video was clearly not an abstract scientific experiment. It was a video made of a stuntman reproducing what the assailant supposedly did by climbing from the assailant's room around the building and across the drainage pipe into the victim's room. And so that does not show any scientific principles whatsoever. And Chris Hadley was not a witness to this event, if it did happen, nor was he an expert that was trying to recreate this event based off of any evidence.
Let me ask a quick question. Forgive me for asking this, but this is a defense witness, right, in a civil trial. My understanding of how these things work is that it's generally the plaintiff's burden of proof in a case, right? And they have to usually show that evidence is more likely than not probable, correct? Within a reasonable degree of probability of whatever the expert is involved. Right? You have to show you have the burden of proof in a case.
Absolutely,
right?
Your Honor.
The defense generally they don't have the burden of proof, and they have the right, though, to show what it may be possible, but not probable to to offset evidence that's presented by the plaintiff in any particular given case. Is that correct?
Yes, Your
All
Honor.
right, so their theory of the case in this case was that the entry was not gained by a key card, but that it was gained by climbing the balcony. That was the theory of the case. That was the competing theory, key
That's it.
card versus balcony.
Absolutely correct.
So if this is a demonstrative, it wasn't a recreation. My recollection of the record is that the jury was specifically instructed that this was not a recreation, but that this was a demonstrative aid to help show or aid the jury in understanding the witness's testimony. Why can't they sit there and present some sort of, particularly in this case, which was with a curative instruction, why can't they present evidence of what is possible to support the defense's theory of case when they don't have the burden of proof?
Well, I don't believe that the burden of proof relates to whether a particular piece of evidence is admissible or not. I would assert that the same argument could be made for any piece of inadmissible evidence, that someone should be able to provide some sort of response. In this case, the case law that I've shown in the initial brief.
But the jury was specifically told that this was not something that was a recreation, but it was essentially a demonstrative aid to support the witness's testimony. Is that not correct?
Well, that is correct, Your Honor. Absolutely. Okay.
So, and is it, in the trial judge's opinion, is that not a 403 analysis, kind of weighing probative value versus prejudicial effect on such a demonstrative aid?
Well, that analysis is necessary, of course, Your Honor.
Sure.
The question, though, is that whether that, based on the case law that we have, they perform the right analysis under that standard, and that would be the substantial similarity test. There's no reason, I believe, to assert that it is not an error or not reversible merely because the jury was informed that this was not literally in images of the assailant doing these things. The problem is that
Shouldn't
it
we
appeared to
assume
be.
that the jury's going to follow the trial judge's curative instruction? Isn't that what they're instructed to do?
Well,
Absent some sort of aberrant verdict, which may have shown they weren't listening to the judge's instruction. I mean, isn't there a presumption that jurors will follow the judge's instruction in such cases?
Well, in terms of whether there was been an error in introducing something, I don't believe so, Your Honor. I don't believe that the cases reflect that simply having a curative instruction can cure such an error that influences the jury in that circumstance. I'd like to point the Court's attention to the CSX case. This is an example to explain why I believe that. The CSX case is the 11th Circuit Court of Appeals for the United States, of course, involving a video that was shown to the jury. And the jury in that case, it was very clear to them that it was not an actual representation. And in that matter, however, because the video itself was intended to show the base version of events that the defendant in this case was trying to prove, and that video itself was not substantially similar and did not have a proper foundation, the Court found that it was reversible error despite the fact that it was clear to the jury at that point in time. In fact, I would suggest that, if we were to say that simply curative instructions could ever be used in such a circumstance, there would be no rule there would never be any reversals, because it would always be clear to the jury that such videos are not actual, videos of the incidents in question. But because that sometimes does happen, these cases do have reversals, which is what we've cited as such in the brief.
But we do have to consider the sufficiency of the curative instruction in determining whether to reverse, right? I mean, we can't just ignore that there was a curative instruction.
Well, of course, Your Honor. I mean, what you're walking towards is the issue of error and how harmful an error would be. That's not a question of whether an error had in fact occurred. I would like to point out the fact that the Court specifically stated that the video was not substantially similar. It's not that we have to go into the mind of the Court and try and guess what was being considered or guess the test that was being done. The Court stated for itself that it was not substantially similar. And that's like saying that something has no foundation and it's not relevant, but I'm still going to show it. And that is, showing that there's just an error, because that's just not the way the cases hold.
Is there any difference in your mind between what is purported to be a recreation versus a demonstrative aid?
Well, it depends on what the video is. I assert, showing the rule is that videos must have substantial similarity as a matter of foundation. So whether they're brought forth, claimed to be a recreation or not, they have to be substantially similar.
But why aren't the facts here a little different? I mean, your theory, the plaintiff's theory and the appellant's theory in the case was that entry could not have been acquired through the balcony. It was an impossibility. And so the defense theory isn't necessarily recreating the entry through the door of the room, through the stolen key, which was the plaintiff's theory, but rather to really counter that theory that it was impossible. And so it's not really recreating an event per se, it's to demonstrate that it can be accessed, and that was exactly what the testimony of the stuntman was, correct?
Well, I would actually say no on that, and I have three responses to that, if I may. The first is that the question was not whether it was impossible. The question was whether it was probable, and it was a human decision-making, not whether human biomechanics can physically do that. People are very different, and there are certain people who can do incredible things. And so it wasn't a question of whether if someone could have done it. It was a question of whether this person did that. And so, for that reason, it was not, even under that circumstance, it's not a very effective scientific experiment to show that it was possible, even if that was what they were doing, because every person is different. Last week I saw that someone climbed El Capitan, a mountain in Yosemite National Park, 3,000-foot cliff, and he did it without ropes. A video of that incident doesn't necessarily show that anyone else chose to do that. It only shows that this person was able to climb it. In this particular case, the question wasn't whether there was any capability. The question was whether it was the likely decision made, and whether we showed.
And understanding that argument, the probability argument, again, the stuntman's testimony coupled with that demonstrative aid, why should the defense be able to present that evidence?
Well, simply because the concern is that the video itself, videos are very prejudicial, inherently prejudicial, as we've cited in our brief. Video, jurors retain 650% more from videos, so much so that they're more effective than actual real evidence. And so the problem is this is a genesis of evidence. This is something that had no evidentiary basis. Chris Hadley did not observe what occurred. Chris Hadley was not an expert. He did not, take evidence from the scene and try to recreate it. This is not like an accident that was being recreated from an expert. This is just someone that just climbed around the side of a building. And such a video just has no factual benefit to the jury. The jury does not gain anything by seeing that this occurred.
Okay, I just want to interrupt. You're down to 2 minutes if you want to save time for rebuttal.
Well, yes, Your Honor. I want to make sure that if there's any question of whether this is not reversible error, I want to address all of this panel's questions.
That's your choice.
Okay. Otherwise, I'd be happy to reserve the rest for rebuttal. Thank you so much.
May it please the court. My name is Edgardo Ferreira, and I represent Baxter Realty, Inc., also known as El Governor Motel. I think there are two critical aspects, and I think the court did touch upon this, that makes this particular video different from the ones that are cited in plaintiff's cases. One, the video was never actually admitted into evidence. It was just shown to the jury, and there was a very specific curative instruction given prior to the video being shown, which stated that this was not a recreation, that it was not supposed to be taken to evidence, and that the jury could ignore the video if they wanted to. Most of the cases that were cited by appellant have to do with the admission of the evidence of a video into evidence, and that's why many of the times the court reversed, should not have been admitted into evidence. We don't have this in this case. And the video itself is not a recreation at all. It was a visual aid to aid the testimony of Mr. Chris Hadley. All he did was testify. When he was testifying, he just pointed to the video and said, "This is what I did." It reflected his testimony exactly. Basically, the video just showed how Hadley climbed from one balcony to the other. It just basically showed the feasibility, the ability that a human being can actually do this, cross the balcony, nothing more. Even in their brief, in their initial brief at page 19, they concede that the testimony was admissible. They never objected to it. They didn't try to go for a Daubert motion or anything like that. They waived any objection as to Mr. Hadley's testimony. And I submit to you, to this court, that because they did so, they also waived any objection to the video being shown.
But isn't the appellant's counsel correct in terms of the power of the video? And in this case, having looked at the video, the stuntman makes the breach of the balcony look effortless. I mean, certainly that would have been a very powerful image for the jury.
Your Honor, I understand that, and I agree that at some videos may be prejudicial, but in this particular case, it did not have to be substantially similar because it was just showing the physicality, the physical ability of an individual to do this. And there is no way that a jury would have mistook this video for an actual recreation. Daylight, he was wearing a harness.
You bring up that point. I mean, that was some of the dissimilarities of the circumstances. So you had someone who was a professional, who apparently was sober, and
Yes.
who was harnessed and was doing this in the daylight versus in the evening time.
Correct,
So,
Your Honor.
so those are all differences, arguably.
And not only that, but they were also, he was cross-examined extensively, and all the dissimilarities were pointed out. Therefore, there is no way, in my opinion, that the jury could have thought that this was anything but just the testimony, Mr. Hadley just...
What was the purpose of the video coming in, other than to show he did it easily?
Just to prove the feasibility, because it was Mr. Woods, who was the negligent security expert that plaintiffs retained, said it would be virtually impossible for anybody to do this. It'd be crazy, it'd be death-defying. So that video was, Mr. Hadley was retained to show that it was feasible, and it wasn't virtually impossible.
Well, counsel, how is this not different than some of the cases cited by appellants such as CSX, where the defense put on a different, recreation video to show, feasibility of a different theory of the case? Why is this different?
In CSX, some of the videos were not exactly, some of the video, I believe the train car was put at an angle. It wasn't done, it wasn't done to help. It was done more to show that the brake, the way it was done is to show that the brake would have held. That's what they did. And it was done, it was twisted in such a way where the brake handle would not have gotten loose. Not only that, the video was actually not done by the person that wanted to introduce the video. It was actually done for an OSHA investigation. And I think those are clear differences here.
Wouldn't that make it more admissible that it was done by an independent third party?
No, it was done, but it was only done for the OSHA investigation. That's it. I don't believe.
I mean, I'm not sure I understand that. Why that?
Well, I'm just saying that there are differences.
There's
here.
differences,
There are
but I'm not sure
differences.
that difference helps you.
I understand, Your Honor. And I don't know if you want to hear any more questions about this, but I do want to touch upon the fact that there was a foundation for the introduction of this video. Prior to Mr. Hadley actually testifying, there was the testimony of Ms. Williamson, who testified that she thought that the individual, the assailant, had come through the window. There was also testimony from two officers who investigated the incident, and they came to the conclusion that the assailant came through the balcony window. There's also testimony from a paramedic who was told by Ms. Williamson that she believed the individual came from the window, from the balcony window. There's also testimony from the minor child who overheard his parents, or Ms. Williamson, Mr. Webb, speaking.
Excuse me, sir.
Speaking to.
Hold on 1 second. Thank you.
Who overheard speaking to police saying that they believed that the assailant came through the window. So there is a proper foundation. There was actually evidence in the trial record that shows that this was a possibility. And one of the things that the initial brief says is that there was no evidence. And we take umbrage at that because there was plenty of evidence to do so. And mind you, that evidence also would go to, if there was error into introducing this video, we believe that there was more than enough evidence to make it harmless. And it should be harmless under the 59.041 statute. And interestingly, this also goes to our argument that they waived and abandoned some of the issues because they did not file the entire trial transcript. And in harmless error analysis under 59.041, you have to review the entire record. And if it wasn't for Appellate, you would not have the entire record before you. Another thing I'd like to point out is that the video did not become a focal point of the trial, other than the one mention in opening arguments, second, two mentions in closing arguments, as well as the direct and cross-examination of Mr. Hadley. It was not mentioned again throughout the trial. And I think that goes, and I think that also helps the argument that that if it was error, it was merely harmless. Your Honor, unless you all have any questions, I believe my presentation is done, and I'll cede to whatever time is left to
Okay, thank you, counsel.
I have just a very brief rebuttal I want to point out. This entire case was about two competing theories. And just like in the CSX case, when you have one competing theory providing an inadmissible demonstrative or inappropriately shown demonstrative exhibit, that is reversible error because we cannot show that that's harmless when the video itself goes directly to one competing theory against another competing theory. And so, under that circumstances, there's no way that we could ever say that this was harmless or that the jury did not consider this at all. Videos are extraordinarily powerful. And I do want to point out one other issue is that the whether we do have cases that show that you cannot simply exhibit something in order to of what a person did in order to show that that's what they did, just to explain their testimony. That was discussed in Chenette v. State, the 4th District's Court of Appeals case regarding a person reenacting porcelain being thrown at a window. And that was discussed in State v. LaRue, which is these are both cases that were cited in my initial brief, where a person was trying to show that it was possible to climb in a car in a certain way, and the court found that because the actor in that case wasn't drunk like the person was in the case, then that was not an appropriate video because you cannot just show what someone did. There has to be a foundation of substantial similarity. If there's not any further questions, thank you very much.
Thank you both counsel for an excellent oral argument. Seeing no further cases in front of the court will stand at recess.
All right.